fireside chat, which on trends in global data privacy. So before we get started, just a few housekeeping items. Before I introduce the speakers, closed captioning is available. You can find that at the bottom of your webinar screen. This webinar is being recorded, and we will make the recording available publicly, and we'll send it out. We'll send it out via social media. And while I'm speaking about social media, I'll let you know that if you aren't following Albany Law School on LinkedIn and other social channels, you should do so. We have a lot of programming, such as our Women's Leadership Initiative, perspective from our faculty on breaking issues, and then happenings in our Justice Center, which is our in-house public interest law firm, just to name a few. So for today's webinar, the Q&A function will be open, but the panel, as we're getting started late, so we will have limited time, I think, to answer questions, and the panelists have a lot to share with you. So do limit your questions to things that you feel are pertinent to the whole crowd. And when the webinar is over today, please do fill out our quick survey to help us refine our programming and to help us plan for future topics that are of interest to you. Related to today's event, Albany Law School, I want to let you know, offers a number of fully online graduate programs that serve professionals looking to advance their careers in various industries. These are not just for lawyers. Our courses provide a legal and regulatory perspective on an industry in which you may already be working as an attorney or not. Our programs are designed for flexibility with the adult learner in mind, and our faculty are current industry professionals whose experience, connections, and personal insight are among the things that our students value the most. Our cybersecurity and data privacy program, the program connected to today's webinar, was the first of its kind at any US law school. And I want to play for you very quickly a video about this. Just bear with me while I pull it up.
Hi, I am Dean Antony Haynes, and I created the Cybersecurity and Data Privacy program at Albany Law School to help professionals like you advance their career.
Law.com reports that data privacy and cybersecurity officers are in high demand with little competition, and IAPP reports that 42% of all cybersecurity and privacy. Click below to learn more, and we look forward to speaking with you about how Albany Law School will help you advance your career to the next level.
Okay, thank you, Dean Haynes, for doing that pre-recorded bit for us about the program. So just a little bit more about the program, and then I promise we'll get to our speakers. We offer a 9-credit graduate level certificate, a 30-credit master's, and a 24-credit LLM for attorneys looking to better apply their knowledge of the law within this space. The LLM can be completed in as little as 12 months, the master's in as little, or in a little over a year, sorry about that, and the certificate in just a few months. Our courses run in 6 terms throughout the calendar year, and students can begin at any one of those terms, so we're highly flexible. Our other program areas, in case you might not be interested in this one, are health law and healthcare compliance, financial compliance and risk management, human resources, law, leadership, and policy. And launching in 2022, we're very excited to announce a brand new program, which has been a long time coming in the online space for Albany Law School, Government Affairs and Advocacy. For the time being, we can waive the application fee for anyone who submits a completed application package. And if you happen to be an Albany Law alum from the JD program, we're currently able to offer a 50% tuition discount for our LLMs online. If you'd like to learn more, please give us a call, 518-603-6132, or email graduateadmissions@albanylaw.edu. Without further ado, let me introduce you to today's moderator, who I said is Associate Dean for Strategic Initiatives and Associate Professor at Albany Law School, Dean Antony Haynes, who will introduce our speakers today. Dean Haynes.
Thank you, Tom, for that warm introduction. Before I introduce the speakers, I want to re-emphasize the focus of this particular fireside chat is on this idea that the world has seen an explosion of data privacy legislation in the last 18 months or so, and that privacy professionals and corporate compliance officers are scrambling to ensure ongoing compliance with a growing array of regulatory approaches while not restricting business growth and innovation. And so we've invited two outstanding experts to help us, and I'll be acting as a moderator, understand these trends. We have Bseikri, who is the vice president and senior counsel at Apple Bank in New York City, where she focuses on privacy in the financial services space. Nada has an extraordinary history prior to serving in that capacity. We also have Barry Cook, who is the head of privacy and the chief data privacy officer at VSF Global. He has extensive experience navigating global data privacy laws, risk analysis, and policy compliance. And then I am Antony Haynes, your moderator. I am the associate dean here and also the associate professor at Albany Law School, who is responsible for the cybersecurity and data privacy program. So without too much further ado, let's get to the questions in the heart of today's fireside chat. So the first real general group of questions is identifying the trends that we're seeing here. So this question is going to be directed to Barry to begin with. What are the trends in data privacy regulation, and what does the future really hold for privacy law and regulation in general?
Yeah, thank you, Dean Haynes. Thanks for that question. It's a really good question. And as you correctly say, we've seen an explosion in data protection legislation over the last 18 months. And I was reading something earlier this week that was saying there's something like 84% of the world now is covered by some form of data protection legislation, be it a hardcore data protection legislation or written into some other legislation or into a Bill of Rights or a constitution. So really, it's no longer something that's sitting on the fringe. And as we've seen from a lot of media, it's very much well out there, and it's certainly something that any privacy professional has to consider, the global impact. Now, one of the trends that we are seeing is with this explosion of data protection legislation, what we're seeing is a kind of coalescing into three buckets or three pillars, if you like, on the different styles or types of data protection legislation. And those three pillars form around the rights-based pillars, the harms-based pillars, and the controls-based pillar. Now let's dive into that a little bit deeper. What does that actually mean? Well, the rights-based pillars is primarily legislation that's modeled around the GDPR, the European GDPR, which has at its core a set of rights that are built into different constitutions, primarily the European Constitution of Human Rights, that actually says that privacy is a right, and the legislation is reflecting that right. So that's a privacy-based pillar. The other pillar is a harms-based pillar, which is what we see coming out of sort of North America, the US, where the focus is actually on the harm that occurs should something go wrong. So we're talking about data breach notifications. We're talking about what to do in the event of a breach, the impact, the harm it has to the individual if a certain criteria is not met or a certain criteria is broken. So that's the harms-based. And then we see the third pillar, which is the controls-based pillar, which is what we see coming out of countries like China and potentially India, Russia, where the actual legislation is highly specific. It really talks in fine detail of how this legislation should be implemented, with a set of controls that regulate and control how that privacy model is to be implemented. And we're seeing with the evolution of the different data protection laws, and a lot of these are first-time data protection laws, they are either modeling themselves on one of those pillars. And that modeling is based typically on sort of geopolitical history of those countries and whoever the commercial, trade and political alliances sit. So we're seeing it's following that. I mean, we have some interesting areas in the Middle East, for example, which have really influences from all three of those pillars. So then it becomes very much more of a decision around economics and politics as to which pillar those laws fall into.
Thank you, Barry. That was both informative and insightful. So we have these three broad categories: the rights-based approach from the European Union, and perhaps the GDPR is a good exemplar of that, the harms-based approach in the US, and then the controls-based approach in countries such as China and Russia. So Nada, the question for you is, what is your perspective on the emerging trends? Do you see them breaking down into the same general patterns that Barry sees? And looking at the United States in particular, do you see any distinctions here based upon how we approach data privacy regulation?
Yeah, I certainly agree with Barry that these three trends, thematically are what we're seeing globally. And I think the geographical alignment is definitely important to be mindful of in that context. In terms of kind of how it plays out in the States, it's an interesting time as a privacy practitioner to see new legislation domestically emerge, because we do see kind of a blending of some of these risk-based frameworks with some of the more rights-based approaches from the EU and from countries that have adopted more or less an EU-like sensibility about their privacy regime. So you do have states that have either the three that have passed, California, Virginia, and Colorado, that have passed new laws, or other states that have laws either actively in their legislation or in the pipeline, perhaps being revived in a future legislative session, that some of the concepts around rights that we saw in the GDPR are starting to make their way over and coexist in some of this drafting with our existing harms-based approach. And I think the California CCPA is an interesting one, because it in fact has a private right of action that is keyed to a data breach incident, and yet the remainder of the body of the law itself is a new emphasis on rights. And so it is interesting to kind of see how these emerging trends in legislation are intersecting, at least in the States, and I'm sure globally as well.
Thank you, Nada. And I should point out for our attendees an interesting geographical note. Barry is coming to us from the European Union, from the member nation of Switzerland, and Nada is here in the United States, coming from the East Coast in New York. So we do have international representation on the panel here. So we're getting definitely both the EU and the US view on these emerging data trends. So going back to Nada, I'll direct this question to you. What does this really mean for US-based companies that are looking to do business around the globe? How does having these three broad regimes, the rights-based regime in the EU, the harms-based in the United States, and then the controls-based in China, impact a company that's really international in its business perspectives?
I think kind of your opening remark kind of encapsulates the ongoing and perpetual struggle, I suppose, that organizations have, in that it is a struggle to remain evergreen in a legal framework, in a legal landscape, rather, that is not static. I think, historically, aligning US practices with other foreign regimes is not totally unseen. Before GDPR, we did have the directive in Europe, and there were some cross-border transfer considerations there as well. So it's not a brand new state of affairs for American organizations, but it is perhaps these are more robust frameworks that we're working within now. And so, cross-border transfers have, the movement of data from the EU to other countries has always kind of been a contentious area for global privacy and trade considerations. And those will continue and will continue to be refined, and they will continue to be more contentious perhaps, and be more granular in the issues that arise. I think right now the hot topic for at least American organizations is, how do you lawfully move data now after Privacy Shield has, become defunct, and the limitations perhaps that could arise with standard contractual clauses, which are those default uneditable contract terms that you can use to legitimize your movement across the Atlantic to the US and other countries for that matter. If those perhaps have some limitations in connection with our US national security posture, what does that look like? And as these issues are coming to head moving forward, organizations are going to continue to have to reckon with new developments in that space.
Thank you, Nada. And referring to the Schrems cases, Schrems 1 and 2, as well as this renewed collapse of the data transfer protocols, is something we need to get to in today's fireside chat a little bit later. But before we get to those cases and that issue, I want to go back to Barry and to dive a little bit deeper into some of the differences in the origination of the EU's approach versus the US approach. And I'm thinking about EU Charter Article 7 versus perhaps the US 4th and 5th Amendments, and kind of how that's really shaped a view on whose rights are being protected and how they're being protected by these data protection regulations.
Yeah, thank you, Dean Haynes. Yeah, I think it is very important to look at the history of where data privacy legislation has originated. And as you say, the GDPR and the directive before that is based on the Human Rights Charter. We have to turn the clock back a little bit on why is the Human Rights Charter held so sacrosanct in many ways. And we have to go back really to the sort of unpleasantness of the Second World War and the history of what happened with countries there and the utilization of information. And back in the day, before the days of Google, heaven forbid, how would we do research then? People used to go to bookshops. Bookshops were Google of the day. If you wanted to find something out, you would go to the bookshop. You would stand and read a book. You may even purchase a book in that respect. And the same for libraries as well. Certain sort of elements would coalesce at bookshops, and they would become areas for maybe the people that didn't align with the political agenda of the day, and political parties and the enforcement agents of political regimes would go to the bookshops and ask to see their reader list, ask to see their order list, take that away. And that's equivalent, I suppose, to looking at someone's browsing history, as we would relate that to today. And and as we know from the events of 80 odd years ago, there was a lot of persecution and victimization based on someone's political beliefs, somebody's ethnicity and religion. And that's where the Human Rights Charter had its founding in. It was written to prevent that ever happening again. And it was written into one of the fundamental rights, human rights within the European area. And one of those fundamental rights is the right of privacy and the right to live effectively undisturbed. And we can see parallels there to the First and Fourth Amendments in the sort of history. And if, as we know as law grad students, that the American legal system did originate originally from the English legal system, common law system, etc., and has then gone off onto its, its own particular version of it. And so there is a history of how that came out. Now, if we take that as the basis of where the GDPR has come from, it's come from legislating that right. In other words, it's saying, okay, this is a fundamental human right. How do we support that? How do we put a legal framework in place that is going to support that fundamental human right? And that's where we had the directive and later on the regulation, which is governing the do's and the don'ts, shall we say, of handling personal information. Now, comparing that to the US system, and it's my view as an outsider here, and not being brought up in with the Constitution, simply learning it through my coursework here. The view of the Constitution that I have is it's primarily written to protect the public from the government, is how my opinion. That might be a controversial view, and I accept that, but As an outsider, that's how it appears. The First Amendment is protecting people from the government infringing their right to freedom of speech, right to practice a religion. The Fourth Amendment, which comes from the old English rule days, is preventing the government or its agency invading your home, which is sacrosanct. So that there are parallels there in a right to privacy, but there's no explicit right. There's an inferred right to privacy in the amendment. I mean, Nada, you probably speak better to this than I can, but that's how I perceive the difference. And I see this is how the different frameworks have evolved, where we talk about this, the rights-based versus harms-based version, because there's an infringement where the government or another party has infringed one of the amendments, and that gets carried down into the legislation at state level, as we're seeing with the original data protection laws, and to a certain extent with the other laws of California, etc., that are coming out. So it's very important to see the historic view of where the origin of these regulations and statutes has come from.
Thank you, Barry. Very helpful insight into the EU perspective on this. So it seems as if what we have perhaps, and I'm going to direct the next question to Nada, is that we have perhaps a more human rights based approach in the EU's data privacy regulations and regulatory regime, whereas I think the race you used, Nada, was more of a consumer protection approach in the US. Now, I'm going to push back a little on that characterization. I kind of see it more perhaps as different property rights. So in the US, it's the corporate property ownership over your information and the ability to kind of generate profits from that data information, and then trying to balance that with sector by sector approaches on it, if it's healthcare data or financial data or these different segments. So it's different rights here, and maybe it's less about the individual privacy. But I would be interested, Nada, in your view on this, and then also after you show your view on this, what does it really mean for companies that are trying to design at least a two-pillar framework that would at least work in both the EU and the US? Do we take a risk-based approach, like the opting in when you agree to share your data with the corporate organization, or do we take a more opting out, which might help to maximize profits because people are by default going to be in the system and they have to by exception opt out of the mailing lists?
So let me kind of tackle your first insight there, following up on Barry's observations. It is interesting to kind of imagine our approach as being property oriented and having a property interest in, information about yourself. And I think that may potentially influence some of the more consumer protection approaches we've taken to personal data and data protection and privacy. So I certainly think that's at play. Perhaps, the key takeaway, I think, though, is that nonetheless, regardless of what's influencing our approach, at the end of the day, I don't think we have elevated privacy as an inherent human right in the way we have seen in the EU. I think we've done much more compartmentalization in the States in that regard, either framing it as a property interest, framing it as a consumer protection interest, framing it as a protection from the intrusion of the state, and all of these kind of sub-frameworks. The totality of them all maybe still don't rise to the level of a human right and elevating it at a kind of sacrosanct level to use Barry's language there. As for the second part of your question, what does it mean for a US-based organization that needs to comply with diverse legal frameworks, rights-based frameworks and harms-based frameworks in particular? I think the incentives for picking and choosing perhaps exist, and there are organizations that will evaluate their global activities and take the most rigorous approach in certain geographies and take a less rigorous privacy approach in other geographies. And then there are organizations that are looking to have a universal and uniform strategy globally, where they will take the most rigorous approaches and apply it universally to all their operations, whether they are legally obligated to do so or not. I think, one that comes to mind, Microsoft, I know when, and maybe this is less of a, I guess it applies both globally and also domestically, but when GDPR and then CCPA both rolled out, they did take the approach in both instances of being, embracing the more rigorous standards as their default and operating in that way moving forward, so that as new laws and regulations come online, you do have that more evergreen approach that won't go stale, that won't need revamping. So there are pros and cons to both. I think, for those companies that choose to have certain rules and standards for parts of the world where the regulations locally are more restrictive, the pro perhaps is that you get some of the economic or commercial benefits of being less regulated in those other geographies. The flip side of having a universal approach is that you have one compliance standard. It's not a patchwork for your organization. There's predictability. You're not monitoring things in silos and responding to things in silos. So on that front, I think there are pros and cons, and we see examples of companies doing both. You touched on, specifically opt-in versus opt-out regimes and frameworks, and what that means for an American organization that may be operating globally and required to have opt-in approaches in some jurisdictions and maybe only opt-out in other jurisdictions. It's an interesting question, because organizations have kind of reacted to an emphasis, at least American organizations have reacted to a new emphasis on opt-in in some different ways. And, one example I think of is kind of in the marketing space, where, traditionally we have a very heavy kind of unsubscribe culture and legal framework around how our marketing communications go out, right? So everyone's familiar with the button at the bottom of the email. You don't want to see future emails. That's kind of our default approach here. As companies are contending with opt-in regimes where you need to have somebody decide to receive marketing communications on the front end, I have seen marketing teams where, in past roles where they rationalized or saw the benefit of an opt-in approach by understanding that you may have a smaller pool of folks that you can communicate with, because you have to have that initial step of people choosing to receive your communications. And while it may be smaller, the quality of engagement can change over time. So you have people who really do want to hear from your company. They do want to stay abreast of promotions and all of these other things that an organization wants to communicate out to an existing or potential consumer base. So while it changes the calculus, I think that over time, we're going to see that some of these commercial benefits do ultimately emerge when we, as US organizations, are shifting to more rigorous standards. They're not so draconian that there is no commercial value in the marketing effort anymore.
Thank you, very helpful. If it's okay, I want to return to a topic we raised earlier, which was the Schrems decisions. And I'll start with you, Barry. First of all, could you kind of explain for the attendees exactly what happened in the 2015 Schrems case, the first one, and in the 2020 Schrems case, the second one? And then also, why is it that the European Union keeps invalidating the data transfer shield on the one hand, but then finding the SECs, these contractual clauses to be valid? It seems that they should both fail or both succeed.
Yeah, that's it's a good question. And I think that there's lots of privacy professionals who are still trying to get their head around that. So if we go back to the original Schrems case, Max Schrems, an Austrian law student at the time, back in the original case, he took Facebook to task that Facebook were handling his data without his permission, primarily. I won't go into too much depth of the case, there's a whole case study alone in that one. He took that, took Facebook to task. He had to take it through the Irish Data Protection Commission because they were the lead supervisory authority. It's one of those concepts that exist within the GDPR framework, that any company that's operating in Europe has to have a lead supervisory authority, and it has to have a main establishment within Europe. And what that means is it's effectively its seat, its legal seat within Europe. The purpose being that a data protection regulator can get its clause in if there are any sanctions. That's sort of putting it bluntly. So the Irish Data Protection Commission decided this was far too big a question for them to answer. So they pushed that up to the European Court of Justice, and eventually it came through. And the original Schrems ruling, which was highly influenced by the Snowden revelations, the original Schrems ruling was that passing data from Europe under the safe harbor model at the time was not offering sufficient protections to that data. Now, the European data transfer model is a little bit aggressive in that it says that receiving countries should have a similar standard of data protection as the sending country. The GDPR set the bar very high in 2018 in doing that. And the directive before that was actually quite a high bar in many respects. And there were very few countries that actually came up to meet that, what the European Commission calls adequacy, has an adequate data protection framework in place. Long story short, the original court ruling was that Safe Harbor was not offering sufficient protections as a scheme. Various shortfalls, self-certification, FTC weren't actually monitoring it as heavily as it could have been, or for the likes of the European Court. So the European Court said, okay, we can't use Safe Harbor as a framework for transferring data. A little bit of time passed, and the Privacy Shield was generated, a much better and much more rigorous framework. And it's actually, in my view, quite a practical framework. It worked well to actually deal with the free transfer of data. Max Schrems decided that he would take this forward again. Under the same clause, under the same argument, rather, that the original that Safe Harbor was struck down, and that was down to the alleged excessive surveillance of the intelligence community on data that's passed through over to the US. Now, highly controversial, and lots of discussions I've been in on this course are saying, well, hang on, why are the Europeans saying this about the intelligence services, and the European intelligence services are unregulated? GDPR makes no reference to the European information or surveillance models that take place. And just as a little, if I may, just a little sidetrack, because I do think it is relevant to the discussion. The GDPR itself doesn't make any reference to surveillance activities by governments, and that's because there's a separate regulation that does. And it was actually drafted at the same time as the GDPR. If getting a bit privacy geeky here, the serial number 679 of the GDPR is followed on by 680, which is the regulation for law enforcement, intelligence services, and handling of data. So the GDPR was never intended to apply for law enforcement and intelligence services. It had its own separate regulation. So that's why we don't, in rebuttal to the claim that GDPR doesn't cover it, no, it doesn't. It was never intended to. There is another regulation. So anyway, coming back to the discussion, Schrems 2 effectively looked at Privacy Shield. European court said, American surveillance, security service surveillance is still in place. We're going to strike down Privacy Shield as well. And it left us with this mess, really, of what do we use as a legitimate framework to move data from the European Union over to the US. And we've got this standard contractual clause model, which is very heavy, very burdensome. We have to do a privacy assessment of the country where the data is landing, and that has to be built in to these standard contractual clauses. Now, why is an SCC usable and why isn't a national framework usable? Well, it is actually a technique we use in my company for dealing with countries that we may be transferring data to that don't have data protection law to fall back on. If something goes wrong, as a CPO, I want to be able to reach out and grasp the offending entity in that country. And I can only do that by applying national law. We're not talking about the extraterritorial reach of some of the data protection laws here, but using national data protection laws to pursue an entity should it have infringed. Now, in countries where there isn't that opportunity, what are my options? Well, my options, I have to revert to law of contract. So I build into my contract all of the same safeguards that would be offered if there is a robust data protection law in place, except now I'm enforcing it under law of contract, which exists in almost every country of the world. There's a law, some form of law of contract. That means by proxy, I'm applying data protection legislation, but through a different legal instrument. So this is why SCCs are considered acceptable for transferring data, but Privacy Shield safe harbor isn't, because there isn't that, if you like, judicial backup to safe harbor and Privacy Shield in the same way as breach of contract would be there with a standard contractual clause. So long story short,
yeah, that's a great insight and explanation of the two decisions. Before I return it back to Nada, I would like to solicit questions from the attendees. So please feel free to type into the chat if you would like to have a question addressed, and we'll do our best to address it before the end of today's fireside chat. So with that reminder to our attendees, we're going to go back to Nada and to see what are your views on, from the US perspective, on the complexities and challenges in transferring data. Did Barry kind of hit it on the head, or there's some other issues here that we should be concerned about as well?
No, I think he absolutely captured the challenge as well. I think one additional kind of wrinkle, I think, coming out of the Schrems 2 decision is that the transfer impact assessments that Barry was referencing a moment ago, they anticipate that an organization is going to identify and, to the extent possible, mitigate shortcomings in the data protections available under the SCCs. And so while absolutely these SCCs are intended to be the contractual equivalent of a legal framework that would protect personal data, what does an organization do if they are moving data from the EU to the US and they identify national security as an issue in their transfer impact assessment? What becomes of those SCCs? Are they still valid? And if they're not, aren't we running into the same issue we've run into with Privacy Shield, that ultimately they are undermined by our intelligence activities stateside? So I think that's an odd wrinkle, and I don't know what measures or controls an organization is meant to take to counteract the impacts of intelligence activities. That seems like an unfair and tall order for any organization, whether EU-based or US-based, that's moving data across the Atlantic to the States. Of course, that's a very unique issue for just the EU-US relationship. Standard contractual clauses work very well in other jurisdictions that have not been deemed adequate by the European Commission. So overall, I think there's a reason why standard contractual clauses still operate globally, but the US scenario is a very interesting predicament, and I think everyone's kind of anxiously awaiting some kind of resolution, because ultimately, whether it's a transfer mechanism or SECs, the intelligence impacts are still there.
Yep. Very important point. And I do want to get back to the idea of national security and data privacy, whether it's the US, the UK, the EU. But before that, we do have a few questions from our attendees, and I'll direct the first one back to Nada. The first question is this. Are there any suggestions for individuals who are seeking to transition into this area or into this career as a field?
So, the first thing that comes to mind is to have, to the extent possible, an interdisciplinary lens and an interdisciplinary skill set. Obviously, everyone comes from some kind of a professional background. I have a legal background myself. There are technologists who come from that space into the privacy area or cyber area. But ultimately, I think having some functional understanding wherever you come from of the legal frameworks, the technical considerations, either for your organization or for the industry that you're looking to be in with respect to privacy or cybersecurity, and also having kind of a business operations lens where beyond the technology and the legal frameworks, you understand, for lack of a better word, how sausage is made internally at your organization. How is it conducting business? What are those processes? All of these things in a vacuum, while valuable and important, they really become, the value is multiplied many times over once you can combine all these skills and these interdisciplinary sensibilities.
Thank you, Nada. Barry, you have a unique perspective as being a current student in the Albany Law School program in this area. What are your thoughts about how one might move into this arena or to this career field?
Yeah, thank you. I think Nada actually encapsulated it well there. Typically, we see privacy professionals coming up from two streams, from the legal stream, from the technology stream. And that technology stream typically tends to be information security. There tends to be a lot of InfoSec people within the privacy world. What I love about working in data privacy, and I'm from the technical stream, hence doing my master's at Albany Law, so I can actually get to understand the legal side as well. And that's a wonderful thing about the course. It enables that sort of bringing together of the two streams. And one of the things I love about working in data privacy is, as Nada described, you're communicating with all of those different segments of a business. The business side itself, you have to deal with the HR side, the financial side, and then also the legal and compliance side. So we're talking about going across business, and I'm not sure many occupations actually have that spread and that breadth and depth that is needed for a privacy professional. How do we move into it? It is important to have an understanding, and I love that expression, how the sausages are made. I'm going to steal that one if I may. It is important to understand how the business does the business, because it's not just about applying a law in saying, well, I'm sorry, business, you can't do this under whatever law there is. In my belief, any proper privacy professional should, you have to say no sometimes, but there is almost always an alternative. And that's the important thing, I think, to understand. If you understand the business, you understand the various areas that you are advising, working with, then you can offer those alternatives. So moving into it is get a good spread of how your business works. If you're coming up from the legal side, start to understand how tech works, because tech is heavily embedded into data privacy now. There's a clue in the title, data. Tech is heavily embedded, so it is necessary for someone on that legal stream to start to move to tech, and on the tech stream start to move to legal. So whatever stream you're coming up in, bear in mind you've got to make that crossover at some stage, through a great program like we have at Albany Law, or through a technology program if you're coming up through the legal stream. It is a specialized area, but in that respect, it is absolutely fascinating. It's really dynamic. No 2 days are the same in business. In fact, no hour is the same in business because of this dynamic approach. And if you're working with multinational companies, I don't think there's any more rewarding job than actually doing what we do.
Absolutely. Thank you, Barry. We're getting a blitzkrieg of questions here, and I will do my best to address all of them. I'm going to take this one directly myself. The question here is this: the technical side has been well documented via degrees and certifications and training and so on. However, in regards to the quote unquote law, what type of law should you pursue? Criminal, medical, Department of Defense, and so on. Specifically, which genre in the law? And so there are, again, as Barry pointed out, both the IT side and the non-IT side. Now, uniquely, in my experience, I have both the IT and the law perspective. I was a computer science professor many years ago before becoming a law professor now, so I can see both. But most people only have one side or the other. And you can be a data privacy professional without having the IT degree. As a matter of fact, most lawyers do not have that technical training until they actually go into the field and begin picking it up on the job. So the question here then about which type of law is, it doesn't matter. It's your industry. If you're in healthcare law, you need to know HIPAA and high tech and the healthcare regulations. If you're like Nada and you're in financial services, you need to know FINRA and all the fintech regulations for technology and the law, Sarbanes-Oxley, Brown-Blake-Lally Act. There's a whole range of regulations in the financial area. So it's industry by industry in the United States. If you're in the EU, it's the GDPR, and it's much simpler for you from knowing all these conflicting regulations. So it's a bit different here. The next question I'm going to jump to is going to be, we'll start with Nada on this next question. It's really from the perspective of a SMB. So for a client's going to come into your door, an SMB, and this client is a small business that's having challenges relying on contract law for privacy. It can be very expensive for a small business to do this, to negotiate the contracts and to actually go through all the regulatory hurdles, or I guess contractual hurdles, to make things work. So, is there a certification, maybe an audit, maybe some type of vendor cert that can help companies that are looking for good vendors to help them with the data transfer itself and also the contract negotiation?
Sure. So, and I assume we're just talking about SMBs that are moving data entity to entity here, as opposed to their internal program, right?
Yes, I would assume the former, yes.
Okay. So yeah, I think it can feel like a very overwhelming task, not underwhelming in the slightest, an overwhelming task if you're a smaller scale organization to tackle some of these issues, especially if they're not domestic regimes that you're looking to navigate. So I think, outsourcing can be your best friend, whether that be finding a legal firm that is well-versed in these areas that can help you take that lift There are also organizations, one that I've worked at in the past, TrustArc, that is heavily involved in the certification space. When Privacy Shield existed, they coached clients and supported kind of their compliance efforts internally so that they could come into compliance with the Privacy Shield rules and be in a position to self-certify and move data across the Atlantic. So there are a number of players in the kind of law firm and vendor space that can be of service to an SMB that may not have the capacity to tackle these things in-house. It's a growing marketplace. There are solutions and software and human consulting and you name it. It exists at different price points with different levels of intensity and rigor. So I don't think SMBs are completely on their own, but it may require a bit of shopping.
Thank you, Nada. And so the next question I'm going to direct to Barry is from one of my old-time colleagues. Like, we go back decades in the Air Force. And the question is this. It seems that a multinational but United States incorporated nonprofit is placed in an impossible position with trying to comply with the data transfer regime under the GDPR. And so the question here is, and I guess we can have both, we'll start with Barry, do you see a cost reasonable solution for nonprofits in this situation? And maybe your answer is similar to Nada's for the small business approach as well.
Yeah, what we can do, if you're looking at, coming back to the previous question just first, in looking for quality vendors, you can look for certifications that that vendor has. The international ISO certifications, ISO 27001 for security, ISO 27701, which is a bolt-on for privacy management system. So look for companies that have that. Also, NIST framework is really solid, as we know. There are lots of national and international certifications that your vendors can subscribe to, which would work to a certain extent in lieu of having highly robust or highly complex contracts. I wouldn't actually advocate not having contracts in place, but also on the standard contractual clauses, the European Union and a lot of law firms have published very, very easy to use contract builders. Basically, you answer a series of questions, and at the end, you just get a contract that suits that particular transfer that you're making. Really great tools out there. So you don't necessarily have to, invest a massive amount as an SMB. These are tested and proven by law firms, so you're getting a quality contract at the end of it. Now, coming back to that, what are the alternatives? I think the European Union hasn't left many avenues available for transferring data. Really, it has to be these contractual clauses. And honestly, they don't actually have to be highly expensive, because as I mentioned prior, there are a lot of great online facilities from law firms who have actually published these. And I think we could probably, sticking my neck out here, but push around some links to that, or people can just simply jump onto Google or Bing and just search for SCC Builder, and there are a host of them that come up. So coming back, it doesn't have to be expensive to set it up. Yes, it can be if you are engaging a huge law firm to actually do that for you. As regards non-profits, clearly, I would recommend that. And also, just bear in mind, there's a lot of data protection officers who do pro bono work. There's a huge network of data protection officers that are very happy to work for non-profits pro bono. So, don't forget that channel as well.
Thank you. So it appears that we're almost out of time, but I really want to give one final opportunity to each of our panelists to express their final thoughts. And so we'll start with Nada, and then we'll end with Barry.
Final thoughts. Sure. So, kind of reflecting on those initial observations we had about, trends in the privacy space and legal landscape. It is an incredibly active time, and developments are popping up left and right. I think as, from an organizational perspective, it cannot be an area of your compliance that's neglected. From a professional perspective, there are opportunities abound right now. And I think that, I can nerd out about how I enjoy the interdisciplinary nature of privacy and the ever-changing nature of privacy. But, for anyone that is interested, there are so many problems to be solved and challenges to take on that it is not a static, career space. So, from, again, organizational front, from the professional front, very active, and happy to chat with anyone who has an interest in either of those, insights or observations.
Thank you, Nada. Barry.
Yeah, thank you. Closing points. A lot of privacy and privacy programs are looked at from a compliance focus. We have to be compliant, and it's seen as a cost center in effect within any organization. And I think we have to bear in mind, compliance is the floor, it's not the ceiling. So what a lot of organizations are doing now is effectively branding themselves as privacy for profit, in effect, which sounds a little bit radical and controversial, but companies now are differentiating themselves by using privacy as a brand enhancer. You can trust us with your data, kind of approach. And companies do see a positive impact on the bottom line by having a robust and transparent, and that really is important, a transparent data protection framework in place. There is a concept now of people of data sovereignty. My data belongs to me. It doesn't belong to you as the company. So what are you going to do with it? If I take my car to the shop, I don't expect you to be doing an Uber service while it's being serviced. So it's that same kind of model. There's an expectation of transparency. There's an expectation that the data will be handled in an appropriate manner. Companies should look to using privacy to their advantage, and that's not a negative, that's a positive, by embracing privacy, making it part of a strategy of any company. And it should be up there as one of those values of the company, because it does have a positive impact. It does have a positive impact on the bottom line. It has a positive impact of working with your clients, be it above if you're or below if you're directly dealing with business to client, business to business customer. And I think the thing to remember with regards to privacy is that regardless of the business we're primarily in the business of trust, and it's the trust of handling that data in an appropriate manner. That has to be maintained for any organization, any business, to actually properly look after the information of the individuals. Thank you.
Thank you, Barry. I believe at this point, we'll turn it back over to Tom. If we had more time, I'd give you my final thoughts, but guess what? You can email me or come to another fireside chat to get Dean Haynes' final thoughts as well. Tom,
go for it. Give us your final thoughts. 30 seconds or less.
By 30 seconds or less. Well, this is what I will say. I am a bit of a turncoat on the issue of technology and privacy. So when I was younger, I was all about this idea that technology is great, and I'm all about automating and making robots and machines. And as I've gotten older, I've become a lot more technology averse. And so I'm sort of like a neo-Luddite in a way. And so that means then that I cling to this notion of privacy with my cold fingers, and I don't want to release it, even if maybe privacy is dead. And so it warms my heart to think that there is a vibrant conversation around data privacy and the regulations for how to transfer data. It means that privacy is not entirely dead. There is still some notion that we care about your personal data from a legal perspective, from an international as well as US legal perspective, and that it does in fact matter to how you do your business. And so the idea that maybe, as Barry pointed out, you can take it as a marketing advantage. We protect your data, we rent your data. That could be a good sign for the future. So those are my final thoughts on this topic. Thank you.
Thank you, Dean Haynes. So Professor Bseikri, Barry Cook, thank you so much for joining our panel today and lending your expert viewpoints in this ever-evolving landscape. We could probably do the same thing next week and it would be different, right? And thank you, of course, to Dean Haynes for moderating this fireside chat and for keeping the coals stoked along the way. You see what I did there? As a reminder to the audience, please do fill out our survey that my colleague Nicole has been putting in the chat. It does help us improve our events for the future. And if you have any questions about our programs, please don't hesitate to get in touch. That does it for today's event. Enjoy the rest of your day, everyone. Thank you.